Hello, everybody, and thanks for joining us. We are excited to launch our educational sessions that will take place every fourth Thursday of each month with our special education ambassadors, Lisa Wilson and Keisha Godwin. So, with that being said, today we're going to give a session on IEP updates. So, what I'm going to do is open up the door for our two ambassadors to take over. Hello, ladies.
Hello, hello. Um, hi, hi, everyone. I am Keisha Godwin, Special Education Ambassador and team member. Excited to be here, giving some knowledge of my many years of special education advocacy.
My name is Lisa Wilson, Special Education Ambassador and also team member. It's a pleasure to be here today to share some IEP highlights with our viewing audience on today.
Okay, well, with that being said, ladies, let's jump right into our subject matter. I know we have a lot to discuss. A lot is going on, and people want updates. People want to hear what's going on, and so do I. All right, so I'm going to turn it over to you guys. And of course, as you know, as I have questions, because you all are educating me as well, I'm going to jump in and ask my questions along with our audience.
Absolutely. Well, because Keisha and I generally work with families across the country, um, the topics that we come in contact with most frequently, we believe it's important to share with the larger viewing audience. And so, one of the topics that we have recently um, encountered is FERPA, and that's an acronym FERPA Act, the FERPA Act, and it's the Family Educational Rights and Privacy Act of 1974. And I think it's important for us to state 1974 because this is not a new phenomenon. This is something that was put into place to protect the privacy of children, educational records. In the context of IEP, IEPs and 504 plans fall under this umbrella of protection. So FERPA reaches beyond IEPs and 504. And if you've had a child in college, you probably encountered this when you tried to say, hey, I'd like to talk about my son's grades. And the college challenged you and requested a copy of your FERPA form, because when you have an adult child in college, that child becomes its own adult entity, and then they have to grant permission for people to access, to include parents, to access the records. But for the purpose of this discussion, IEPs and 504 plans are covered under FERPA. And before I pass it over to my cohort here, I just like to state that educational institutions that receive federal funding, and that's very important for parents to understand, that when a school receives federal funding, there are laws that they must comply with, because they are what we consider to be recipients of federal funding. And so I will pass it over to Keisha to talk about FERPA and share her thoughts and her experiences with it. And then I'd like to come back and close the discussion to explain some penalties and the enforcement, the U.S. Department of Education, their enforcement arm.
Yeah, so I think, in my opinion, I look at FERPA as, for me, it's like the Bible of special education. It's your good book. It has all of the good news in it. What it has, the protections, the outlines, the guidelines in which the school systems, regardless of the states in the United States, must abide by. And I think one of the biggest things is for people to understand that schools may have laws, different districts may have different guidelines set for IEPs, their counties, the states, that may seem a little bit slighted from FERPA. I want everyone to know that FERPA trump state law. So school districts may say, well, we do it different here. No matter how you do it, it must fit within the federal law and within those federal guidelines that are provided in FERPA. So one of the things that I say to parents is to get abreast of FERPA and its outline to make sure that your child is actually receiving the education process or educational outcomes that are aligned within FERPA.
I will say, ladies, that in all the times that I've gone into IEP meetings, I get that parental guide, the policy and the laws. I have never heard of this. This is very interesting. I've never heard of this. Can you all tell me, is this something that is given out at IEP meetings? Is that a standard? Or how is this factored into the IEP process where the parents are aware of their rights?
Well, I like to speak to that. So bringing FERPA down to the ground so that our parents can understand and wrap their heads around what we're talking about today. Essentially, what we're talking about is access to your child's educational record. And so, yes, in the parental safeguards, and we all have our own opinions about the parental safeguards, it's an enormous, voluminous amount of information that is compressed into a very small font, usually between 10 and 12. And it is just pages and pages and pages of regulatory information that parents have a difficult time digesting, especially without the benefit of of an educational advocate or legal representative such as an attorney. But to bring this down to the ground in layman's term, we're simply talking about accessing your child's educational record for the most part. That's the overarching issue that we want parents to understand, that they have an unlimited opportunity under FERPA to access their child's educational records at any time. And that access is expanded to also amending the educational record. We can talk about, Keisha, we can talk about amending the PWN. That's something that generally is that parents should be amending when it doesn't meet or follow what happened in the IEP meeting. And then not only accessing the educational record, Paula, meaning you get to view the record, you actually have an opportunity to obtain a copy of that record. And I'll let Keisha talk about the 45 days. Like, this is really, really important. And I'm glad you asked that question, because while FERPA is very broad, for our conversation, we want parents to be empowered here today to understand that they can at any time request to have access to their child's record.
Yeah, so to obtain the FERPA, or, well, not the FERPA, my apologies, but to obtain your child's special educational records, you need to file a written request. So that's just basically send an email to the special education liaison, principal, teacher, or your IEP team itself, and just say, I would like a copy or like to receive John Doe's special educational records. The clock starts ticking then. The district, they have 45 days to get those records to you. Oftentimes what we see is that they may get closer to the 44th and 45th day before they would give you those records. But nonetheless, the clock starts ticking once you send that email. And I just lost my train of thought right there, because I feel like I lost my train of thought because I just got caught up in thinking of two families now that have requested their special educational records, and we're outside of the 45-day window. And what happens whenever the school district doesn't give you those records within that timely manner? You file a complaint, which is called what, Lisa?
A FERPA complaint.
It's a FERPA complaint. And you can file it on the state and federal levels.
Because IDEA also grants access
to those records. And The reason why I say that you want to be abreast of FERPA is because you want to have access to your child's special educational records, because whenever you're meeting with the team has access to these records. You don't want to be the one that's ill-informed making decisions on your child's education and their future. And you want to make sure that the data that is presented is actually data that is accurate. And that the team is operating in good faith, which is something that may or may not happen within different school districts.
I do want to say that I'm glad that you brought up that it's also state and federal, because IDEA applies. It's a federal law that applies to state educational agencies. But one of the good things about this is that our children normally are covered under multiple layers of federal regulation. Here, IDEA actually goes beyond FERPA. And so there is an area of strength in that particular legislation. The reason I believe it's very important for parents to understand, first of all, to access your child's record and to understand why it states Family Educational Rights and Privacy Act. And those of us, especially you, Paula, most people who are employed by the government understand the Privacy Act in a very serious context. And that context applies here because it protects your child's personal identifying information. So not only does it protect their name, the fact that they have an IEP, their grades, it protects various layers of their personal identifying information, and then other information in their educational record. And some of the violations of FERPA include unauthorized grade disclosures, discussing a student's information publicly, that one pretty much is obvious, and using group emails with visible recipients. One past occasion, I received an email from my son's teacher about my son's behavior in the classroom, but it was another child that he was having a behavior with. And so the teacher sent the email to myself and the other parent. That was a FERPA violation on its face, because even though she was notifying us, she should have notified us individually. And I'm assuming she may have been trying to use a feature in Outlook where you can send one message to multiple recipients without the other recipients knowing. We know there's blind copying, there's all kind of features in there, but that technically was a FERPA violation. I didn't take action on it, but I did raise it in the IEP meeting. So just to give you an example of that, but most importantly, what I want to talk about is disciplinary records. Your disciplinary record is a part of that educational record. And this is so important. Keisha and I are dealing with a case right now where we are going to be addressing the context of the educational records. So before I go any further, understanding that if your child has a disability and they are facing disciplinary action, suspension, expulsion, anything serious on that level, the school district is required to hold a manifestation hearing to determine if that behavior is born or connected to that disability. Okay, and that's a special layer of protection for children with disabilities. As we know, the United States Supreme Court recently decided that juveniles can no longer be given the death penalty. So this is all very important. It talks about their brains, and we know many of the children that were up for the death penalty, they did have disabilities. So understanding the serious context of when a school is taking disciplinary action towards your child. Now I'm going to stay focused back on FERPA. The reason that's important, because say you decide you want to move to another location, say you a child grows up and they want to go maybe perhaps work for the government, the educational records are inspected as part of those background investigations. So what I'm trying to say is that this is a real legal record that follows your child, and it can cause your child to be excluded from employment opportunities and other educational opportunities, to include private schools, because before private school will accept a child, they will inspect the educational record. And so if you don't know what's in that record, you can be ambushed, and it can be probably very unpleasant for you and your family to receive a denial of services, or for that child to later on in life go into the military and have a wonderful career, and then decide they want to exit and work for the government, and then they're subjected to a background investigation, and then here they are trying to, many years later, explain why this information is in the record. And I'm not saying that the disciplinary information can't stand, but it gives you an opportunity to appeal legally to make sure that the child isn't being punished based on their disability, a manifestation of their disability, which is why those manifestation hearings are absolutely critical. Okay, I'll stop there.
This is awesome. I mean, and I'm intrigued. It's funny because you never really thought, because I know for my son, when he's had a background check with different jobs and they went back to the education, sometimes those background checks are very, they're very lengthy, they're extensive. I never thought about them going back to the education records. Is there now, say that you pull your child's education records and there's something in there that you feel like has has kind of been put in there erroneously, is that a time right then and there to start, or is there a process to appeal that or dispute it?
Okay, I'll respond to that. I operate from the framework that you can always appeal and protest what's in your child's education record. Now, if you are unsuccessful, you have an opportunity to write a legal, or I'm sorry, not a legal memorandum, but to write a memoranda to be included in your child's record. So let's say, for example, your child is suspended, the manifestation hearing is held, they still decide to move forward with the suspension. You as the parent have an opportunity to write a memoranda, and I'm just using the word memoranda, but I mean a written statement. And you can state that I don't agree with this. You can state that my child has a severe ADHD. He has a hard time staying focused. The school may or may not have met his special education needs. You can write a letter stating why you are in disagreement with that particular document that is retained in the educational record in the event your appeal is unsuccessful. So that's a very good question.
This is very interesting. Like I said, I've never heard of this, but this is great to know. And I think most of our parents, I will say that when we hear about IEP, we do hear about the various acronyms as it relates to the special needs. But when you're talking about this is very, very important, because this is almost like your child's record from birth, because of course they got the medical records. And then once the school starts, it's your child's school records. That's the beginning of their life, in a sense, and it follows them through life. So this is very important.
It is very important. And I also want to add that if you notice that your child is getting into a lot of trouble in school, a lot of behaviors, the school is calling you to pick them up or to address certain issues, and the school has not suggested a manifestation meeting, then you can suggest it because you're operating in good faith of your child, and we don't want ongoing behaviors to linger when they don't have to.
Absolutely.
Yeah. I think that's
Now,
just
what?
one of
Yeah.
the most important things. Excuse me, Paul. I think it's one of the most important things because what we see a lot is that children's behaviors, and they could be drastically changing. You can see, like we've seen children in crises, and the school has not, said anything. And you see a drastic change in students and their behaviors and even how they're completing their classwork. You go from a honor roll student to barely just, getting by along with behaviors. And no one thought that it was important to say, hey, let's come back to the table. Let's discuss, this child, or let's have a manifestation meeting to see what's going on. Let's initiate a behavior evaluation or things that we can help identify, this what's going on with this child and get them out of crisis.
Great. I went to an expo and I talked to a parent, and the parent told me that her child was not diagnosed with any type of disability, but there was a drastic change in her grades from one grade to another. I mean, it was so drastic. She was a straight A student, and then that next school year, she was going down to almost a F. And I don't know if it's F in everybody's, but it's at the bottom of the grade and totem pole. But the parents were very concerned. The school basically told them that they could not do anything until she actually failed, and they were like outdone. And I was just talking to them about this, and they said that each day they checked that school record to make sure it got to the bottom level. And then they was like, okay, now that she's received an F, now we need to say what accommodations, whether it's 504 IEP, what accommodations can we put in place? Because obviously we see that there's been a drastic change in the grade. So that's kind of like what I'm hearing you guys say is at that point, and I hope I'm saying this right, there should be a manifestation to discuss how that child's grades have changed drastically to see if there's a crisis, some type of crisis or some type of new disability that has surfaced that no one was aware of.
Yeah, I'm not certain, and Lisa, you may have to speak to this with your knowledge, but I haven't seen anything that states that a child has grades have to be that significant from like an A to a F. And if you're saying over grade levels, I would definitely whenever I'm met with something that I'm unaware of, I always suggest for parents to say, can you show me this in writing? Can you show me this in the policy that supports your statement? That way it's not just their policy, right? I think one of the things I said in the beginning is that school districts, their own budgets and stuff, they're working against budgets, but the budgets doesn't have your child's best interest at heart. So if it sounds funny, can you show it to me in writing? I need to see this in policy, or where can I find this at within the policy? Yeah, because that a school to educate a child is okay with a child becoming an A student to an F student before we do anything. So we're going to react and not be proactive to, help support this child so that they can be successful in, their educational journey. That doesn't sound like a school to me. That sounds like a budget talking.
I totally agree. I totally agree.
I just want to add that I just want to clarify, Paula, that a manifestation hearing is when a child is already identified as having a disability.
Okay, thanks for clarifying that.
But it doesn't preclude requesting the school to conduct an assessment and then reaching back and asking for consideration of that if the child is found to have a qualified disability as outlined in IDEA. That doesn't preclude the family from asking for reconsideration of the disciplinary action. I'm sorry, of the educational failure, because from my perspective, that child may be a candidate for compensatory education to try to recover. I don't want to use the word, but compensate that child for that missed assessment, especially if the parents are routinely saying, "Hey, I think it's something wrong. You know, can you assess my child?" And if the school is saying no, that's definitely something you want to capture in writing. You don't want to call and do that over the phone, because when you're capturing that, that's your evidence that you actually requested for the school to assess your child for a disability. So that's very important. I also, as I was sitting here, I wanted to talk, Keisha is pretty big on assessments. And a lot of times parents agree or do not agree with assessments. And also when I talked about writing that written memoranda, if you do not agree with the assessment, and we're talking about the psychological testing that the schools do. They do testing in the area of physical therapy, occupational therapy. You can also write a memoranda in opposition to the outcome, the assessment outcomes. So again, just trying to really hit home as why this power of the parents to respond to that educational record, to review it, to amend it, to request for it to be amended, and then actually obtain a copy. This is a lot of power, because if you don't agree with the assessment, you have an opportunity to respond. My personal experience with that is that they took my son's school district, removed autism out of my son's IEP. So I wrote a very extensive parent statement explaining when he was diagnosed at the Mayo Clinic, and he was subsequently diagnosed by Kennedy Krieger Institute. And so I provided extensive information of his clinical diagnosis in the record, and I asked for it to be adopted inside the PWN and also inside the IEP under the parent input. So again, understanding your power as a parent to have some influence and control over your child's educational record. And before I have two last things. I just want to talk about Social Security, because unfortunately, some of our disabled students, their disabilities impair their ability to obtain employment as they exit the school environment. And so in some cases, they will be eligible for Social Security benefits. Please understand that the educational record is considered when those 18-year-olds are being examined under Social Security. They want to know what that IEP said. And so in my case, autism was not in my son's IEP. They took it out of my son's IEP. Well, autism, once you go under the ADA and you look under the list of qualified disabilities, all disabilities are not qualifying for Social Security. And I'm not an expert on Social Security. I don't want to purport that at this time, but I'm just trying to drive home why it's so important for that educational record to be reviewed and to be inspected by the parents to ensure that it is fully capturing the totality of your child's disability in relationship to their educational experience. I'll let Keisha talk about Social Security a little bit more. She may be, I don't know a lot about that, but I want you to understand that is a very big piece of their examination when they're making those eligibility determinations. I hope that's helpful.
Yeah, I'm not an expert on the Social Security department. However, I will say that the Social Security that individuals with disabilities receive is SSI or SSDI. So those are the two types of Social Security that are possible eligible for some individuals with disabilities.
All righty. So we can close this particular segment out. I just want to talk about the penalties. The U.S. Department of Education, we didn't say if the schools don't meet your 45 days, then you can pivot and you can make a complaint with the U.S. Department of Education or your local state educational agency. The Family Policy Compliance Office at the U.S. Department of Education, they are the enforcement arm. And so what happens, there are penalties, it can be fines, it can result in an employee suspension or termination, it can result in the loss of federal funding, and it can result in other disciplinary actions by the U.S. Department of Education. Now, I'm going to be a realist here. There hasn't been a lot of activity, enforcement activity in the area of FERPA. So most likely they're going to receive a letter from the Department of Education telling them not to do that anymore, to do what they did anymore, like a spanking of the hand. So I don't want to get parents, I don't want to overshoot your expectations that the government is going to come sweeping in and take, serious action. But it's all about documentation, and that's what's important.
Yeah. And I think it's important, I want to piggyback on that because I don't want somebody to lose hope, but I think it's important because some cases we have seen have gotten so bad where parents, basically have to take legal action. And you want things to be documented to support your claim. And without documentation, was it really that bad? Did it really happen? So, I'm a stickler for dotting I's and crossing T's across the board for myself, for school districts, for our children within, their limitations, for everybody doing the work. Like if everybody do their part, we can get along as a good team. If our team isn't a good team, then we have to make some adjustments. And, part of making adjustments may include filing a lawsuit against, the school district.
Yes. Yeah. Parents have a lot of rights. And unfortunately, Paula alluded to this in her initial question, is that how would I know about this? Mm-hmm. I don't understand why there is such a concerted effort to suppress this information from parents. It's part of the reason that I'm here today, and it's part of the reason why I have dedicated my life to special education advocacy and being an ambassador, because this information is readily available to the public. And I can't understand why school districts go to such extreme lengths to not empower and educate parents about their rights in special education. And I know, like in where I live, we have a CCAC, there's a state CCAC. These are educational entities that are mandated by IDEA. There's all these parent organizations, but we're talking about parents who don't even know that they are legitimate, bona fide members of an IEP team. Mm-hmm. It shouldn't take a parent safeguard booklet for you to know that. Mm-hmm. That information should be given to you at the onset of the process. And there should be, in my opinion, on a continuum, an exchange and a dialogue where parents are educated about their rights. Not to create an adversarial environment, but to give parents an opportunity, as Keisha always says, is to make informed decisions about their child's educational experience and overall welfare.
Yeah. And that's one thing that I was going to ask. I was like, well, what would be the advantage of the school to prevent the parents from getting these records? To me, I guess that would send up a red flag if I requested and you try to wait to the 44th day or you don't give it to me at all. If anything, parents, for myself, knowing what I know now, that would send a red flag. Like something is in my child's records that someone is trying to prevent me from seeing, or, not giving me the opportunity to dispute or appeal. So I guess for me, those are things that, knowing what I know now, that would definitely be a red flag for me.
Yeah. And it could be a array of many things, the reason why they don't want to give you those educational records. It could be that the data that they've been providing at these meetings isn't in the records. It could have information that probably you should have knowledge of that's not, that you don't, that's in the records. It can be an array of many things. Nonetheless, you have the right to have access to it and to view those records and to have them, for yourself. As the parent expert, parents are experts when it comes down to their children, and not just in education, but in medical purposes as well. Your parent insight, it matters. And if I can say anything to any parent, is to know that you matter and to know that you have a place at the table. Oftentimes you will see parents who are intimidated or even being intimidated by the IEP team in their presence. And I have seen IEP teams try to strong arm parents to dismiss their thoughts and their concerns about their child, but you have just as much right to be at that table and to make a decision as the other members of the IEP team.
Now,
And
I asked this.
one thing, Paula, before you,
Okay.
I just want to say, when I said that you have a right to obtain your child's record, I do want to clarify that sometimes there is a cost that can be associated with that.
Yes.
And so every school district, make sure you understand what that cost may be. Some school districts will just go ahead and give you the educational records. Some, when things become adversarial, they will reach deep down into their policy. You can be charged the hourly rate of the person who is charged with organizing that file. So say your school secretary, say she makes $15 an hour. You can be charged her rate if it takes her 3 or 4 hours to organize that document production for you. So, and I'm just saying, not in every instance, but just understand, parents, that if it is a very large, voluminous record, you can be charged a very minimal or nominal fee. So in every district, in every state, it's going to be different, but I just want parents to know that you can be charged. Now, we are in a digital age, so it makes sense for the record to be in a digital format.
Wouldn't it?
But when I picked up my son's record, it was just giant folders. So I just wanted to put that in there, Paula, so people can understand that there can be a small nominal cost associated with that.
But that's a great point. I'm glad you brought that up, because I was getting ready to ask, is there a certain amount of times you can request it? Like, I know sometimes you make it requested once a year, twice a year. Is there a certain amount of time you can request it, or you can request it as much as you want, like you say, but at that point expect to be charged, because even if they give you one free, if you're going to keep coming and asking, most likely, that's a something to prevent you from constantly coming and asking. But it would be nice to have those files digitally, so that you could just go right in and view them and print them as you see fit. That would be.
Yeah. I think if you go to asking multiple times a year, they're going to exercise those 45 days. So you're not going to get receive but so many of those records. I have yet to see a school district operate in a expedient fashion when it comes down to giving parents access to those records or giving them those records. Maybe 30 days has been the earliest I've seen, but for the most part, they all are pushing 45 for their 45th day. Unfortunately.
This is great information, ladies. Oh my goodness. Great.
Well, we're dealing with these cases across the country, and it just really, it's revealing in that, parents don't know that these are their rights. And then what's equally revealing is how school districts disregard these federal requests for access to their records. And so you have to ask yourself, and I kind of gave it away a little when I said that there's not a lot of heavy enforcement action. And so schools calculate risk on a continuum. And so they look at, well, if we don't meet the 45 days, we'll get a don't do this again letter from the Department of Education. So that's a low risk for them. And so that's why you will see many of these requests go almost ignored, if not ever fulfilled, because of the low risk that's associated with the school being held accountable. But I still want parents to be empowered to know that these are their rights. And we do have a new administration in place, and they appear to be moving pretty aggressively. And so, you always have an opportunity to make those requests and appeals. And if it's not met, then report that at the federal level and also the state level.
Yeah. Follow through by all means. Follow through. Don't be discouraged. Don't say they're not going to do anything about it. Follow through, because again, you never know what the future may hold, and a lawsuit may be in your future, in your view. So I'm not saying that I'm like the person say, oh, let's file a lawsuit. I'm saying that data matters, and should it get to that, you want to make sure that you have the documentation and that the data is there to support your claim.
And I think it's important as well because, like you say, Keisha, that may prevent a lawsuit. Sometimes when you're going to the schools, and I know that I may not know all the laws, but I know from a parent standpoint, what's the saying that, a squeaky wheel gets results. So I think that just doing these things and knowing this information empowers you as a parent. And in most cases, the schools, a lot of the times, if you're lackadaisy and they feel like, I don't have to spend as much time with that child, they do take, sometimes there are great schools. Don't get me wrong. They're great schools. But I do believe that it and not even dealing with just special education, just with your neurotypical children. I believe that as long as they feel like there is no one there that's going to push the envelope, that they do certain things. So for me, I believe in knowing your rights, knowing the law, and having as much information as possible empowers you. And it may prevent that lawsuit from happening just by you knowing, okay, listen, I know I have this right to do this. Can we do this? And sometimes the schools love working with parents that are about their business. So to me, a lot of this is just showing you are about your business and you know the law.
Yes. And I know I said I was done, but I do want to add one other thing. Parents, you can develop the educational record at home as well. And so that entails keeping a copy of every single thing your child brings home. I have a box upstairs. Every single thing that Blake has done, I have a copy of it, whether he was coloring in circles or writing. My child has dysgraphia, which is a handwriting impairment. And so one of the things that I was able to negotiate with the school to get him into a 100% digital access to the curriculum is demonstrating through handwriting samples. Well, what handwriting samples? The work that he was attempting to write at school. And so those worksheets that I'm retaining at home, they become almost an exhibit or evidence to demonstrate that my child is unable. So I have my own educational record here, and they have their educational record, and then we can meet in the middle. So it's my recommendation, especially if you have a kindergartner out there, to just get a box, get manila folders, first grade, second grade, third grade, drop the homework sheets down in there. Don't throw everything away at the end of the school year. They normally send home a a giant stack of papers at the end of the school year. You know how they say your child worked on all this over the school year and they're cleaning out lockers and a desk. Don't throw that away. Drop it, label it in a folder and drop it down in that folder. So develop your own educational record.
I will also say that the work that your child does at home with you, that's a part of your child's educational record. Recently, we've been working with a family, and I'm almost always amazed to see what the individual families do with their children, as far as to help them along to progress along the way. And we've been working with one amazing family who the mom has so much data. So she has videos, worksheets, things that she's created, where she's working with her child. And both of the mom and dad both are very passionate about making sure that their child is successful and independent in his own manner. And the moms or the parents, what their data is very much conflicting of what the data that's been presented by the school. Very much conflicting. So those type of things do happen, and this is you could bring your data to the meeting to say, you're saying this, but here's a video of my child on this day. Here's another video on this day that shows otherwise. We see those type of things, and just know that what your child does at home with you, that's data as well. So you want to collect those things as well. And you can also ask that those things be adopted into their educational records as well. Lisa, you want to say something?
I can't, it kind of escaped me that fast, but I was just saying, I just think it's so important that parents understand how they are a part of the team, and they can bring their data. Their data must be considered as part of the IEP process. I kind of lost my thought, but it's just, this is a very personal journey, and parents must understand that the outcome for their children is inherently tied to our advocacy for our children.
It really is your voice, their voice, like you're your child's voice. And also I would say that just as much as you're your child's voice, your child actually has a voice and has the ability to sit in their IEP meetings. And I would just suggest, like, if possible, if they have the ability to sit, and they don't necessarily have to be there the entire IEP, they can be there for 5 or 10 minutes just to give their own statement. Their opinion on their education, it matters. Mm-hmm. It does matter.
It does. Oh, I know what I was going to say. Present levels. And that's kind of what you're talking about when the mom is videoing the child at home. So present levels in respect to the progress reports that come home quarterly. And they say, oh, Johnny was able to write 5 sentences 5 out of 6 times with 80% accuracy. And so this mom is videoing her child writing 5 sentences. Well, he's not able to do 5 sentences at home. And so that's a way to really bring new information forward to the team and really contradict and impeach the data that the team is bringing forward. And again, I don't mean for everything to sound adversarial in nature, but it's your child. It's your child's educational experience. It's your child's future that is on the line. And so I'm a very serious advocate and ambassador. And I'm very serious because I understand that this is my child. And when he's 18 years old and he's ready to transition into the world, only one person has to look him in the eye and tell him that I gave it my all to make sure that you had every opportunity and access to every legal and federal entitlement to help prepare you for this world. So I'm a very serious advocate, and it's because it's my child's life and future that's on the line. So I don't know if you wanted to pivot right now, Keisha. We did want to talk about, we have about 10 minutes. If you wanted to pivot to the complaint process, I do think, and that's adversarial, but I think it's important that parents understand that the complaint process, it doesn't have to be adversarial in nature, but what it does is it communicates to the school that I believe that you violated my child's rights. And then you lay that information out. And in every state, there's a state educational agency, and they all have a website, and they have a form if you feel that your child's rights are being violated. For example, because what we're talking about today, access to my child's right. So on that 46th day, if you don't receive the records, you have an opportunity to file a state complaint, administrative complaint. And there is a code of federal regulation that's under IDEA that's directly tied to access to educational records. The only thing that I want to bring forward is that you do not have to use those beautiful state forms that are located on every website. You can actually write it yourself. They're just certain information, bits of information that must be contained within. But just pivoting off of our conversation of a school district's failure to provide you those rights, this is a way that you can gain access to those rights, but also filing an educational complaint. Generally, those take about 60 days to be investigated. If it goes beyond 60 days, they will ask you or alert you that a supervisor will say, we may need to extend this investigation period, but in 60 days, and that gives you an opportunity within 60 days to get a response, not only from the state agency, but from the school. And normally when the state agency contacts the school and say, hey, we have a complaint here that you didn't provide Johnny's mom the educational records, and we're initiating an investigation, miraculously, those records show up in your email, or you get an email saying you can come to the school and view the records. So again, it's not about being adversarial. It's about exercising your legitimate legal, state, and federal rights.
And I will also say that it's about access. We have access to our child's educational records, and there shouldn't be any pushback on anything that is basically an option for you. This is a legal option for you, and there just shouldn't be any pushback for you to have access to your child's educational records.
So what we've done here today is we've given you some information about what your federal rights are under FERPA. And again, that's the Family Educational Rights and Privacy Act of 1974. This is not anything new. School districts are very aware that this exists. If they receive federal funding, they're very aware that this is a responsibility. And so we're telling you how to amend the record, how to obtain the record. And then when there is non-compliance, we're giving you information about how to gain compliance. And that is through either a state administrative complaint, and or you can contact the Department of Education directly. I'm just from the old school, that you have to understand that you have to aggressively pursue your rights. And sometimes it does create, it creates tension within the IEP team. For some reason, the schools are very resistant to parents who exercise their rights as far as filing administrative complaints. I was recently observing a school educational board of education meeting where I live, and the special education, the chief administrative officer, I'm sorry, I don't know her position, but she was giving a presentation to the Board of Education saying, yeah, we have this many complaints that have been filed, but 11 of them were by one person. And I just thought that that really fell beneath the dignity of her office, because she was singling out a parent who had filed 11 complaints. So for me, I see that as there's something really wrong, because any parent that has time to file 11 complaints must have some serious concerns about their child. And so understand that if you file an administrative complaint, your relationship with the school and the team may change, but you have to stay focused on your mission. As I say often, this is not a popularity contest. You know, we have to stay focused on what we're here to do, and that is to create, you know, an educational pathway for our children that is equitable and that gives them meaningful access. And so before we close, I always like to remind people of Supreme Court legislation, the Andrews decision from 2017. It was a unanimous decision by the U.S. Supreme Court, and it talks about how school districts have to create reasonably calculated IEPs to ensure meaningful educational progress. And so again, our opening discussion leads into this, because how will you know if your child's making meaningful educational progress if you're not inspecting, monitoring, and surveilling their educational records, which is the work that they're producing, a component of that. And so we have a lot of support in the legislation, but unfortunately, parents, we do have to do the heavy lifting. We do have to do it. But that's what myself and Keisha, we dedicate our time to helping families to do this. And we're honored to be a part of Advocacy, and we are working diligently to create channels for parents to reach out and connect with Advocacy to obtain assistance when necessary. We're working diligently to put the protocols in place and access for parents to say, hey, I need a little help with this. Is this something? Can you answer some of my questions? Or can you accompany me to an IEP meeting? Can you help me interpret the educational records that I have? So with that said, I'm going to go ahead and stop. But just thank everyone for listening today. And just remember, you're the most important person on that IEP team.
Isha.
Yeah, I definitely would say, like to piggyback and say, you are the most important person in the IEP, on the IEP team, and don't let anybody make you feel anything other. Yeah.
You ladies have done an awesome job. Thank you for educating me. And again, I think from my standpoint, and I know most people be like, oh, you're so great, you're so this and that, but I just want you guys to know, don't feel bad if you don't know all of this information, because I didn't. I mean, and Morgan is going on 21, but I appreciate the education from Lisa and Keisha, because I'm gonna say this. There and when Morgan was coming along, there were parents that knew bits and pieces, and we tried our best to piece it together and come up with like information to help each other. So I think this is where advocacy has come from. This is where advocacy was birthed from, because we need this information. The more information you have, the better off you are. And I would rather have more information than not enough. I do believe, of course, Morgan will be finishing school next year. I think this a lot of information that I'm finding out is information that I wish I had years ago. However, if I did have it, advocacy wouldn't be here. So I just really, really appreciate you, Lisa and Keisha, for educating me. Because again, guys, I'm the founder of Advocacy, but I didn't even know about this. So I just want parents to know, don't feel bad. Just listen, take this information and become empowered, spread the word so that we have others to listen to Advocacy. And like Keisha and Lisa said, we are putting protocols in place. We're putting forms in place. We're putting things in place to display on our website and to put on our social media pages so that parents can notify us or contact us to get the help that they need, because ultimately we're here to help. That's what it's about. So again, I thank you guys for joining us. We're logging off, but we appreciate you. Again, this is going to be the fourth Thursday of each month for an educational session. And we look forward to you joining us next week for another session of advocacy. Thank you, Lisa and Keisha. Again, everybody have a great weekend and enjoy your evening. Bye.